SJC-12548, Anna Arias-Villano and others, v. Chang and Sung Enterprises and others.
Ms. Nofi, good morning.
Good morning. May it please the court, Susan Garcia Nofi for the employees. The trial court erred in finding that the employees were exempt from overtime under the Massachusetts agricultural exemption. These employees worked up to 70 hours a week, loading trucks, operating machinery, and performing cleaning and maintenance duties, work for which any other employee in the Commonwealth would have received the overtime premium. Chang and Sung Enterprises are using the 10 automated growing rooms that take up only 17% of their food processing facility as justification for denying overtime to the employees in this case. The employees in this case did not work in the growing rooms. They did not grow or harvest bean sprouts. They performed post-harvest work in a factory-like setting that was in operation for 15 hours a day, 6 days a week, year-round.
Would the result be different if they did work? It sounds like Mr. Chang does the farming, right? He does you're actually farming these bean sprouts, right? The employees that you're talking about may not be, but somebody's farming in there, isn't?
That's right, Your Honor. In the growing rooms, bean sprouts are being grown by automated machinery programmed by Mr. Chang with the assistance of a couple of other employees who are not the employees at issue in this case.
But you agree there's farming going on, or don't you?
I agree that there is farming going on in the grow rooms. However, this exemption doesn't turn on whether the employer is an agricultural business or farms an agricultural product. It turns on what the individual employees were doing. And the employees, in this case, were not doing the farming. Because the overtime statute is a remedial statute and an exemption is an exception to that, the employer has the burden of proving that all elements of the exemption are there.
And you say at least two of them are. You're saying that these particular workers who are cleaning and packaging aren't farming, but aren't you also saying that they're not farming on a farm?
It's our position that, well, I should take a step back. It's our position that there are three elements. The trial court ignored the word "and" between two of the three elements. To be exempt, these employees need to be engaged in agriculture and farming on a farm. It's our position that, that none of the three elements are present in this case. The employees, as I said, were not engaged in farming. They didn't plant, cultivate, harvest bean sprouts. Their work was completely post-harvest.
I think you lost me on that, because I think what I was understanding at first was that if you looked at Mr. Chang and then say the three people that help him out in the grow room, because if you use the term farming, it kind of gets confusing. But if you have people that are working in the room where they grow the bean sprouts, you're saying these aren't your clients.
Correct.
So it's possible, and please correct me if I'm wrong, that under your interpretation, the people that work with Mr. Chang in the grow room could be exempt, or is that wrong?
It's our position that they wouldn't be for the other reason that we don't believe the facility is a farm. But that's not the case. That's not the case that's here today.
That's really important. That's what I'm trying to understand, because I think globally, what your position, this is not a farm, so none of it applies, basically. And I know you want us to decide the case in front of us, and we will, but that's important for me to understand what the parameters are.
Yes, Your Honor. Even if this court were to decide that the entire food processing facility is transformed into a farm because of the 17% of it where the farming actually takes place, our position is that our clients would still not be exempt because they themselves were not engaged in farming.
And don't work in those rooms, right? Okay.
But as to the first point, you say for many reasons, including the licensure issues from DPH, that this isn't a farm, it's a food processing plant.
That's correct. The facility is licensed as a food processing facility. Built into the licensure statute is an exception for farmers growing a raw farm product. this facility was not exempted because they are licensed underneath that. And as was pointed out in both the appellee's brief and our reply brief, the packaging work is regulated as food processing by the
Why
Commonwealth
isn't
of
it a
Massachusetts.
farm? I
Yeah, I'm
mean,
really
I-
confused.
It seems to me it's part of it's a farm.
Can't
I
it be
mean-
both?
The licensing statute doesn't seem to allow for it to be both, but again, if anything is a farm, it would be the rooms where the bean sprouts are actually grown. And again, even if the court were to find that the.
This away from this particular example, and I know you don't want to do that, and applied it to, say, somebody growing corn on several acres, would we then, and say there are different employees doing the growing and the harvesting, and then versus the packaging and the sending out, you'd say that the people packaging and sending out would not be engaged in farming?
That's correct, Your Honor. I believe the court would have to look at whether the employees were actually engaged in farming, because that's what the exemption requires. It says "and farming."
Don't look at the entirety of the enterprise. From the perspective of the employer, you'd look at it from the perspective of the employee. as
That's
to
right.
What task they're
And
doing.
that's what the federal statute does.
The federal statute defines agriculture much more broadly to include post-harvest activities. But Massachusetts broke with that paradigm. They didn't adopt the federal definition of
Right, so
agriculture.
actually it's the reverse with the feds. So basically what you're saying is that the failure of, or the purposeful, I think, broad definition that our legislature used means that we take it away from the federal narrow interpretation.
Correct. And even the trial court, in ruling against us, found that the legislature appeared to have purposefully rejected the federal standard.
Why do we, I mean, I looked at all of the exemptions. They're all very short. Agricultural and farming is not defined. So why would you not look to 128, Section 1A for your definition?
Two reasons, Your Honor. First, the definition that's used in 128, which very closely tracks the FLISA language, was considered in an earlier version of the bill. It was incorporated by reference, but then that was taken out before the final version of the bill, the compromise bill that was enacted. So that was.
So what meaning do we get from that, other than that they didn't choose to incorporate the language of the definition in the exemptions?
I think there are a couple of other pieces to look at in addition to the fact that they struck it from the bill before it was enacted.
Well, you leave chapter 128, because it looks like you're not right on the chief's question. So they took the chapter 128 definition, which is much broader, out of the bill. But maybe they took it out because they didn't need to include it. You already had a definition of agriculture. I mean, that can't be dispositive, can it?
Well, in addition to taking that out, in Section 2 of Chapter 121, the legislature adopted a definition of agricultural and farm work. It is not crafted perhaps as helpfully or clearly as it could be, because it uses the words agriculture and farm to define agricultural and farm work. But what is clear is that definition is not the federal definition. And what's also clear is that it has the limiter that it says "and growing and harvesting." So the definition of agriculture and farm work for purposes of this chapter, which is not Chapter 128, appears to be limited to growing and harvesting. And then the third thing to consider is that this exemption was adopted as part of other legislation that came out of concern for protecting workers in the agricultural economy. It was passed at the same time as the first time that Massachusetts passed a minimum wage for agricultural workers, and at the same time that it enacted some reforms in terms of the inspection of farm labor camps.
But
So
it
viewed in that.
but it wasn't passed. The chapter 151 was passed, and then it was years later, I can't remember how many, 6, 7 years later, that they added the exemption for 19. So there's a decision made after this passes to add the exemption. So
That's correct. After the
go ahead.
Pardon me, yes, absolutely. After the overtime law was passed 7 years later, there was this exemption that was carved out. But the fact that the legislature decided to carve out an exemption doesn't say anything about the scope of the exemption. If the legislature had intended to simply exempt broadly, including post-harvest work out of the overtime protection, it could have simply adopted the FLISA definition. It certainly has adopted other different overtime definitions wholesale from federal law. In this case, they appear to have thought about it and then pulled it out and put in a definition of agricultural and farm work that has the limiter and growing and harvesting.
So where did the lower court go wrong? Because he didn't adopt the broad definition.
Yeah, a couple of places. The lower court seemed to agree that Massachusetts had broken from the federal model and did not adopt it, but then the lower court said that the common meaning of these terms was the very broad definition that the lower court just said the legislature hadn't intended to adopt.
Well, there seems to be something else going on in the lower court decision. Maybe it's the same thing as the American mushroom amicus, is that right? Where there was a concern, it was in the lower court decision, and it's in the amicus brief, that farming's not static. And with technology changing so quickly, having some static definition of farming just doesn't make any sense. It seemed that was part of what was going on in the Superior Court decision.
Yes, and it's our position that in this case, any advances in the technology of farming the bean sprouts in terms of the machinery used or the computer program, that really didn't affect the clients in this case because our clients were not farming the bean sprouts. And the appellees haven't really cited any authority, nor have the American mushroom amici, for the idea that paying these workers overtime for this labor that they were doing would somehow stunt innovation or technological advances in farming.
So what would happen if you had a smaller operation which said essentially from 7 in the morning till 3 p.m. we will farm and we will harvest, and then 3 o'clock on, all hands on deck to package the produce. And we're going to use the same people to do the packaging as who did the harvesting earlier in the day.
If that were to happen, which is not what happened here, then the employer would have to pay the employees differently based on the work that they were doing, and that's not something that's unheard of under Massachusetts wage laws. In other industries, for example, the restaurant industry, you could have an employee that spends part of their time as a server where they're going to receive the tipped wage or the service wage, and part of their time as a dishwasher where they might receive the regular minimum wage. And employers have to account for the different kinds of work, and certainly technology has advanced with timekeeping as well.
In the restaurant, they get below minimum wage because of tips. So, but how would you do the counting here? Which is the overtime? The farming work done earlier in the day for which you get no overtime, or the packaging work you do later in the day for which you would?
That is a question I had not considered, but certainly that's something that could be determined in a case where that issue was raised. But in this case, it's quite clean.
I mean, the legislature are dealing with farmers, some of which are large, some of which may not be so large. Why would they put a farmer in a situation where they have to sort out, during the 70-hour day, I need to figure out what you were doing during the day? If you're out in the field harvesting, you're in one status. If you were actually back in the packaging area, putting all the corn into crates, then that's a different category, and then I'd have to figure out what to do. Why would the legislature do that?
I don't know, Your Honor, but I do know that if the legislature had wanted to simply follow what FLISA had in place from the 1930s, where everybody all along the chain from pre-harvest to post-harvest was exempt, they could have done that and would have done that, and they didn't in this case.
But the Superior Court judge was concerned about this issue. I think that it would be impractical to distinguish between primary and secondary farmers, and that it would interfere with deployment of farmers and innovation. I think that was part of the reasoning.
Yes, and we disagree that that's a difficult distinction to make. FLISA itself makes that distinction between work that is farming and agriculture and work that is merely incidental to or conjunction with farming. The difference is the Congress decided to exempt workers who do both pre-harvest and post-harvest work, whereas Massachusetts had a much narrower exemption that it adopted that was limited to workers that were farming.
Can I follow up on the chief's question in the beginning? And referencing something the trial judge said, the motion judge said, exemption shows that the definition from agriculture from GLC 128 was considered and explicitly left out from the final exemption language in 151. What's the basis? Did someone argue that to him that presented the legislative history and said it was considered and explicitly left out?
Yes, Your Honor, it was first raised by the amici American mushroom growers, who also filed a brief below, and then we argued it as well, and it should be in the addendum to our brief,
So
both versions of the bill.
So we know that they were, at one point, they had the 128 definition in it?
That's right, Your Honor. The original version of the bill had the 128 definition incorporated by reference, and then the final version that was passed, along with the other reforms, that was taken out.
And do we know if that earlier version included many definitions for many of the exemptions? Or was it just this definition which was omitted?
I believe it was just targeted at this particular, the agricultural exemption, but it is in the bill that is attached to the brief.
One more question. 128, Section 1A speaks of farming or agriculture, and that has a single definition. You say there must be agricultural and farming, as if there are different definitions. What do we do?
Well, our position is that when construing a statute, we assume that every word has meaning. And when we look at the agricultural exemption itself, there's a reason it says "and farming." And in other case law cited in both sides' briefs, agriculture is a much broader term than farming. So if the legislature could have simply left it at agricultural workers on a farm or exempt, but they did use the language "and farming."
All right, thank you.
Thank you.
Ms. Lundy?
Your Honors, good morning. My name is Sandra Lundy. May it please the Court, I'm here with David Gabor of the Wagner Law Group on behalf of the defendants, whom I will collectively call Chang Farms. Your Honors, the plaintiffs have just asked you to write them out of the agricultural exemption by judicial fiat. The judicially imposed restrictions that they would like you to place on the very broad language of the statute are incompatible with its common meaning and would lead to results that are harmful, absurd, and nothing that the legislature could have intended. I want to focus on three issues today: the legislative intent, the breadth of the statute, and the probable consequences of affirming or vacating the Superior Court's judgment. Now, we know that statutory language remains the primary source of insight into the legislator's intent. And here, the legislature uses three key words to key you into their intent: agriculture, farming, and farm.
But why don't we start with the actual language? Any employee who is employed as a laborer engaged in agriculture and farming on a farm, isn't that narrower? Engaged in, is employed as a laborer engaged in agriculture and farming.
That's right, but the words agriculture, farming, and farm don't appear anywhere else in the overtime statute. And they didn't appear at all in the overtime statute for the first 6 or 7 years of its existence. So I think that we could presume that the legislature looked at the original law and thought it swept too broadly, and it moved to protect agricultural economy. Now, why would they do that? And I would ask you to look at the analysis that Justice Spina has in.
If you're right, why didn't they just use that 128 language, which is so broad, or the whatever the federal language, which is also clear and broad, but they just didn't do that, right?
They didn't do that, and they didn't do that within a context in which the legislature was acting against a backdrop in which federal decisional law, state decisional law, federal statutes, and state statutes had all construed those words very broadly. They were acting against a backdrop of at least 100 years of statutory interpretation, which says that you interpret the broad words of a statute broadly. So you would think that if the legislature wanted to limit the meaning of agriculture or farming or farm, they would have put that limitation directly into the statute
They did.
rather than risk this broad interpretation.
But they did. So we don't have the Fair Labor Standards Act broad definition. It doesn't differentiate between primary and secondary. We don't have the broad language from Chapter 128, but they did. There's a definition of agriculture in Section 2.
Section 2 applies to Section 2. It doesn't apply to Section 1, and it could have because the legislature could have said it applies to Section 1. Section 1 is the overtime, 1A. Section 2 concerns minimum wages for farm workers. The legislature, the judge made his decision based on the common sense understanding of agriculture, farming, and farm. He's essentially, the way I read his decision, he says, I don't even have to go to the outside periphery of what 1A, Chapter 128, Section 1A, or the FLSA might define as farming. I don't have to talk about silviculture and horticulture, because the Chang farm workers are farmers engaged in agriculture and farming on a farm, because when you think of what farmers do, you think of growing the crop, you think of cultivating the crop, you think of distributing the crop, and you think of, what the judge said, every conceivable thing in between. Now, it's interesting to me that the judge doesn't cite the building inspector versus Curvin opinion that we cite.
Would that include the truck driver?
There are no truck drivers in plaintiffs.
No, but I'm asking you, if you're saying it's from seed to supermarket, right? Would it include the truck driver who takes the pallets of corn and drives it to Stop and Shop?
I think that's pretty fact dependent. It doesn't occur here. What the plaintiffs did, the only commodity that goes into Chang Farm is raw sprout seeds. The only commodity that comes out are raw sprouts. The only commodity that the plaintiffs handle are raw sprouts. And what they do is they make sure that they are cleaned, they're safe, and that they're properly packaged before they go into the stream of commerce. Now, I guess you could argue that once they're on the truck, they're in the stream of commerce, and that's something else. But what the plaintiffs do is embedded in that interdependent series of tasks that we think of when we think of farming. And that's what the judge said, and he based his decision on the just plain meaning of the words.
So do you think the people in the grow room, and I'm probably using the wrong terms, would be covered as well?
Oh, yeah, yes, absolutely. I think this is a farm. There's no question that it's a farm.
PH doesn't seem to think so. I know there's a report where they mention it as a farm.
Your Honor, I would beg to disagree. What the plaintiffs did is they took a small clause from Chapter 94, Section 305C, and they used that to argue that any farmer is exempt from the regulations because they're not food processors. Well, first of all, Chapter 94 deals with food processors or distributors. We have a distributor of raw vegetables. If you look at the entire statutory scheme, if you look at Chapter 94, Section 305C, in conjunction with 105 CMR 500 and 105 CMR 590, this is the way that you understand the statutory scheme. That farmers who sell directly to consumers, their raw products directly to consumers at farm stands or in farmers' markets are exempt from the burdensome regulations that pertain to farmers who sell their raw products in the wholesale market. And that makes sense because, 10 contaminated apples can do so much damage, but 100,000 contaminated apples can do a lot of public health damage, and the risk of damage justifies the higher regulatory burden on the raw food wholesaler. That's all that statute said. It doesn't alter the nature of the work. See, what the plaintiffs are trying to do is to decontextualize and fragment the nature of what they do on Chang Farms. What they want you to focus on is the discrete tasks. They want you to focus on the, whether it's indoors or outdoors, and they want you not to focus on the overall purpose of this activity, which is for the farmer to get the produce into the stream of commerce. Now, there are a number of issues that are that we could cite in terms of the atomization that they want to impose on the statute. And one of the cases that I want to call Your Honor's attention to is Board of Assessors versus Lynn, Sand, and Stone. That's a 1971 case. In that case, Your Honors were asked to construe the meaning of machinery in a statute that provided that machinery for domestic production is not able to be taxed locally. The Board of Assessors came in and said, well, when the legislature used the word machinery, it meant machinery that you can take out of the real estate. But machinery that you have in the real estate, that's not machinery, that's really real estate. And we can tax it as real estate. And this court said, absolutely not. When the legislature uses the broad word machinery, it means machinery. And the court is not free to impose on that broad term what are called narrow or technical distinctions. And in another part of that case, the court says that the use of a broad term by the legislature is not an invitation to the court to basically subdivide those broad terms into what it calls refined distinctions. But that's what the plaintiffs are asking you to do, indoor versus outdoor farming.
Well, just for one moment, and maybe they are, and the regulation might not be their best argument, but it's a remedial statute. There's certainly not, it's not certainly not crystal clear here. And then the exemption doesn't just say agriculture, it says laborers engaged in agriculture or farming on a farm. So obviously those words in and of themselves are much more narrow than Chapter 128 or the federal statute.
That's right, Your Honor, but they are all, but what the plaintiffs do, as I said before, is encompassed in the kind of interdependent set of tasks that one does when one farms to get the produce into the market. So, I'm sorry?
No, nothing, no, I didn't say anything, I'm sorry.
Okay, I mean, if you look at what the plaintiffs are saying, let's look at Cassius is a great case to think of here, decided last term. Cassius says that the legislature's deliberative decision in drawing exemptions to a statute are entitled to just as much weight. They are construed in with the same rules of statutory construction as the overarching remedial statute. And the overarching remedial statute does not serve as an a priori check on the exemption. I think the words of Justice Lank were, the legislature knows how to draw a narrow exemption when it wants to. Well, it didn't want to here, and that's why we have those broad words.
But what are the words? I mean, we have to define agricultural and farming on a farm. So did the legislature want its own definition, or did it mean to incorporate another definition? Where do we look, where do we find the definition?
Oh, we certainly, Chapter 128 is certainly, Section 1A is certainly a good place to look. That statute defines both farm and agriculture, and I do agree, agriculture is a little bit broader than farm.
So why do we go to another statute to get a definition of agriculture when this particular statute has a definition?
Its definition is for a different purpose. And again, you would think.
128 might have to do with zoning.
But,
That's a
but
different purpose.
if the legislature wanted to impose a narrow definition on those terms in subsection 19, given the breadth in which those terms had been almost universally interpreted in statutes and in case law, why would they risk leaving those broad terms out there? Why wouldn't they narrow those terms exactly in subsection 19? They chose not to do it, and they chose not to do it. Again, we can't decontextualize the context in which this statute was enacted. They chose to use those broad terms within a context in which those terms had been used broadly for many, many years. I just want to say a couple things about some other arguments that the plaintiffs make.
Before you get there, let me see, if they put a canning, if Mr. Chang decided to put a canning or some other facility on his farm, would they be exempt, the employees working there?
Well, once you can a product, you transform it. Nothing is transformed on Chang Farms. The soy sprouts, the raw vegetables don't become tofu or mung bean noodles. You know, they get to market. Once you can it, that could be an entirely different process. Now, think about it this way. What if a tornado came and blew off the roof of Chang Farms and blew off the walls, okay? So, and Mr. Chang decided, well, I'm going to take this overground tank, I'm just going to put it underground because it looks better, and I'm going to say to the employees, you don't have to work when it's raining. Under the plaintiff's definition of the statute, what was once a factory has now become a farm. Under the judge's definition of the statute, it was always a farm because the entirety of the work, the nature of the work doesn't change. The plaintiffs talk about the nature of the work, they want you to atomize the tasks and not look at the purpose of the tasks. The judge correctly looked at the purpose of the tasks. And I see that my light is blinking, so I just want to make one more point. You know, of all the amazing tools you have in your statutory interpretation toolbook, probably one of the most powerful is a very simple question. Does this statutory interpretation make sense? The judge's statutory interpretation is logical. It depends on the plain meaning of the statutory terms. It's coherent. It affects and it results in a benign and a benevolent legislative purpose for the reasons that we have in our set forth in our appellee brief. The plaintiff's interpretation does not, and we would therefore ask you to affirm the judgment of the Superior Court.
All right, thank you.
Thank you.